Yes, yes.
Welcome everyone to this session of Daksha Dialogues on careers in dispute resolution. Welcome also to the panelists Sajan Poovayya, Boski, Sharma, Aneesh, Patnaik, and Poornima, Hatti. I'd like to sort of put this conversation a little bit of context. In the past 20 years, I mean, now is a very turbulent time, but it's also the case that in the past 20 odd years, there have been some important changes and very interesting changes in dispute resolution and the law in India. The first, and they've all happened about the same time. The first is the liberalization of the Indian economy in the 90s. A lot of privatization of sectors, which, if one looks at it in the dispute resolution context, led to a lot of new regulations, specializations in regulations, a lot of tribunals. So you have competition practice, you have electricity law practice. You know, this has happened in the last 15 odd years. The second development was the setting up of the National Law School and as a model institution, professionalizing legal education and consciously making legal education something that would start at the undergraduate level, where youngsters would have to choose between, you know, what were the go-to professions at that time, medicine and engineering. And at the same time, so as soon as you finished your class 12, you had to choose between medicine, engineering, which was so well established and highly regarded, and law. But what a change it has been. I mean, there are so many law colleges all over the country. The education has become so professionalized, and it is a sought-after profession today. The third development was, you know, the government taking a more serious look at different ways or different approaches to resolving disputes. So in the late 90s, you had, you know, the Arbitration Conciliation Act that was passed, which modeled itself more on the New York Convention, which brought in conciliation. You had court annexed mediation that was brought in through the Civil Procedure Code and the setting up of court annexed mediation centers all over the country. So these have been very interesting times, and relative to what happened prior to it, a lot of changes, you know, in this time. And our panelists today are people who have, you know, studied law during this period, honed their practices, developed their practices and their skills, you know, with these changing times. So it is going to be very interesting to listen to, you know, each of them and what has happened in their careers and what are the prospects they see, you know, in the legal profession and in disputes resolution in particular. Let me introduce the panelists. Sajan Poovayya is a senior advocate and former additional advocate general of the state of Karnataka. Sajan, prior to his designation as a senior advocate, was the managing partner of Poovayya and Company, a full-service law firm. Poovayya and Company had offices in Bangalore, Chennai, has offices in Bangalore, Chennai, Mumbai, and in New Delhi. Sajan graduated from the National Law School of India, Bangalore. He did his master's in law in the London School of Economics and Political Science. Sajan has appeared in very important matters of public importance. He appeared in the Aadhaar case. He appeared in the case challenging Section 377 of the Indian Penal Code. So great deal of experience he brings to the panel. Welcome, Sajan. Thank you for your time this evening. Our next panelist is Poornima Hatti. Poornima is in charge of the disputes resolution practice in Samvad Partners. She's part of the founding team of Samvad Partners. Poornima's practices in commercial and corporate law. She also sits in as an arbitrator and a mediator. So there are different forms of dispute resolution there for you. Poornima is a graduate from the National Law School of India, Bangalore. She continues to take classes there on contract law and on constitutional theory. Poornima writes extensively about reform in arbitration law. Welcome, Poornima.
Thank you, Chitra.
Next panelist is Aneesh. Aneesh graduated from the Symbiosis Law School in Pune. He joined the chambers of Dr. A.M. Singhvi and appeared with him in very important cases in the Supreme Court. Some of the cases are on the 2G license cancellation, the mining ban, which had, a lot of implications for the country, for regulation. Amish is now with Vahura, where he heads their disputes practice. He oversees recruitment in the disputes resolution area for law firms and in-house. Welcome, Anish. Thank you.
Thank you.
Boski Sharma is a senior legal counsel on disputes and regulatory practice for India and for South Asia in Uber. Boski was with top-tier law firms. She was practicing before she went in-house. She was with the power sector, and her last assignment, her present assignment, is with Uber. Boski advises the group on contract management, on disputes resolution, regulatory compliance, and is responsible for innovative products that Uber brings, and its interaction with regulation in India. So Boski brings individual dispute resolution experience to more sector and regulatory, a more macro sort of perspective, if you will, in disputes and in regulation. Welcome, Boski. Thank you for joining us.
Thank you so much, Chitra, for having me. It's an honor and pleasure.
I'd like to start by asking each of you, if Sajan, you could start on choices you made in your career, either in terms of practice or shifts in your career over time, and what are the important aspects, or what are the important elements to what you do in your practice today? Sajan,
this question can actually have a very long answer, but let me be brief, and knowing well that most of our audience are young minds wanting to actually walk the path of a professional career in the law. I think I should tell you that I have at least not found a single methodology by which I could or could not have done what has happened in my life as a lawyer. But the one thing I can turn back and say is that, one, I have enjoyed every bit of what has happened to me, and I'll give you a few instances of how terrible things have happened. And second, I've really gone back home either victorious in a matter or vanquished, so to speak, but I've never gone back home unhappy. And therefore, that I think defines it all. Every day has been a phenomenally fantastic day for me, as today has been. I've been in court till 4:45 in the evening. And I think irrespective of whether you win or lose, you actually take away something, and that gratification is extraordinary. I think for a litigator, I must tell our audience that I've been a thoroughbred, completely hardcore, traditional, orthodox litigator, nothing really beyond that. But if you really want to walk the path in the litigation spectrum, a few things that you should unlearn. One, don't have expectations that you will have success overnight. Absolutely not. Second, don't have expectations that you will win every matter. In fact, you shouldn't. The issue is that you are representing a brief, you are representing a particular client, and it need not always be on the right side of the law. You actually may have a brief which is on the wrong side of the law, and you will still do your best to defend that brief, or do the best you can in that brief and contribute to the march of the law by losing a matter. And sometimes your losses are more important than your victories in a litigation spectrum, number one. Number two, you also, I think, and to be very, very candid, you have to develop a bit of a thick skin in this profession if you have to survive and thrive. The key is that so long as you stick on, you will thrive. So long as you stick to what you're doing, you will do well. And so long as you continue in the profession, you will succeed. And for all those young lawyers who think there is no money in litigation, yes, the answer is there is no money in litigation in the first few years. But there is so much money in litigation thereafter that you don't know what to do with it. And therefore, please stick on. For heaven's sake, don't walk away from the litigation path unless it is inevitable. And when I said thick-skinned, I did not really mean it in a bad way. I just meant that you need to develop that sense of tolerance for what is thrown at you at the bar. Not all judges will be pleasant to you. Not all briefs will be sweet to you. But for every judge who is kind and who will nurture that inner talent in you, there will be 4 judges who will put you down. Or for every brief which you believe brings about a crucial aspect of the law for you to actually argue, you will have 4 stupid briefs which will come to you. Now, the whole 9 yards of the profession is that to actually take it through and weave these briefs that come to you in a form that ultimately you have a yard of cloth which actually is pleasant to look at. And therefore, if you ask me, I have in the last 23, 24 years, I never really looked at a situation where I have planned my career or planned a future. I have been nudged into particular grooves by particular matters, by particular judges, by particular seniors, and particular circumstances. I have just let myself be nudged into those grooves. And therefore, to keep the play in the joints and to let yourself go and go with the flow is, I think, very, very important in this profession. The last bit I will always say to the young audience is that never get disheartened. You can have terrible days at the bar, but you will realize that it is those terrible days which actually makes you a better lawyer for the future or better lawyer for the next day. And therefore, if you believe that a day was not as good as you thought it to be, just go back home with 3 mindsets for a litigator. There are only 3 states of the mind. That is good, better, and best. Your day has been good. Even the worst day is a good day. If it has been better, so good for you. And if you really won a constitutional matter before 11 judges, that's the best day for you. But there is nothing beyond good, better, best. There is nothing below good. You can't have a bad day as a litigator. With that mindset, I think sky is the limit. And the youngsters of today are far more equipped to litigate than we were. We are the 80s generation. We had little or no foresight in terms of what we ought or ought not to do. But I think therefore, and even in terms of competition, I find that the youngsters of today are actually giving a run for our money as compared to the older people in the profession. Therefore, all is well. Just stick to the profession, continue enjoying what you are doing, and that's the path I walked, and that's the path I would urge that the younger ones walk. You're on mute, Chitra.
Thank you, Sajan. Very encouraging, because it can be very demanding, and it's good to hear this. Poornima, will you go next?
Thank you, Chitra. So there is somebody else, I think, who's not on mute. Just in terms of my own career choices, I have primarily worked with law firms. I'm sorry, there seems to be a bit of background disturbance in where I am. Can you hear me? And am I audible?
Yes.
Okay. So I've lived and worked in Delhi, London, Singapore, and Bangalore. And so I think the challenge is every day if you get up and say you're happy to go to work, all is well. And if that is not happening, you need to sort of see what is wrong or reassess your own priorities. Each day has to be crafted by you. So for me, some of the important things are who I work with. It's important to go back to a bunch of people you can relate to and have a conversation about your day in court or your advice to clients or about the practice of the law. And I think that sort of pushes you on as a group of people to go ahead. So choose who you want to work with as people you can relate to, people who understand you, because each of us are different. I work, for instance, in a law firm that has majority women, both in terms of partners and both in terms of associates. To me, that makes it very, very comfortable. There's not a day when I can go back and feel that, oh, this was said in court. How could they say it? And I get sympathy, I get empathy, and we talk about change. And although that change may be far ahead, that conversation is very true and now. So that's important to me. So choose choose and understand what is important to you. There's never been a day when none of my colleagues or any of my people within the law firm where I work with have said you can't achieve this, right? Anything is possible. So as the world grows smaller, I mean, sitting in Bangalore, we're now having conversations in Singapore, in London, speaking at events across the world. And COVID has really made it happen, right? So you can mediate and arbitrate wherever you are in the world. So dispute resolution is also shrinking as an idea. So again, choose what you want to do and where you want to do that. It doesn't have to be that you have to be physically located in another country. You can truly build an international practice across borders, and that's something you can now be conscious about. While I appreciate and understand why Sajan is saying, have a thick skin, that's something I'm still trying to work on and develop. But I think having a thin skin also makes you want to better yourself, right? When you come back, and I think I've had bad days, but that thin skin makes you want to do better. And I tell all my associates that every day that they have to challenge me, right? And you have to inspire me to do better. And sometimes that inspiration comes from around you. So pick where your inspiration comes and choose it, right? It could be your family. It could be something external. It could be a great senior, wherever it comes. And I think that helps you go from place to place. I went from Bangalore to Singapore to Delhi, and then there were 2 years when I decided to set up my own practice. When I thought, so it was about 3 years down into my career when I thought I learned all of it, and only really to realize that there's so much more to learn when you go on your own, and who's going to push you forward, right? So circumstances will take you into different places, and who you marry, or where you want to bring up your children, many things. But make sure that all of it is something that makes you happy and wants to make you get up and go to work every day. Thank you.
Thanks, Poornima. That was a different perspective, particularly your reference to balances that one makes and choices one makes, professionally and personally. That was important. Boski, will you go next?
Yes, so beautifully articulated by Sajan sir and Poornima. I have definitely something to add in terms of my personal story. So I wasn't there. I don't think I was slated to be a lawyer. I was actually slated to be an engineer because that's what my mom wanted me to be. So the fight for me started early on, when I was wanting to find myself an engineering seat. My father and I came across an article that spoke about ILS being recognized as the top 10 law schools in the country, and that's when my dad said, "Why don't you give it a shot? You'll probably be happy." And I'm so glad that I selected law, else I would have made a horrible engineer. I'm convinced about that today. So to our listeners, I think I'll definitely say that you need to be honest to your natural inclinations. If a career in dispute resolution, or law for that matter, is not your cup of tea, please do not give in to peer pressure. You must be happy and excited about what you're doing and about the new things that you're learning. So that's the limited point I'd like to add.
Anything about your work in law firms and your shift to an in-house position?
Oh, yes. So I started my career in Bombay and had the chance to work with Bombay High Court, and then decided to have an individual stint at Aurangabad High Court. But like Poornima rightly said, there was a point in my life where I said there's so much more to learn. And moving in-house will definitely give people a 360-degree view of, what are stakeholders' expectations? How can we give more purposeful advice to when you can be an individual contributor, when you need to be a team player. So all these added perspectives only end up making you a better professional. So my personal belief is that gaining exposure on both sides of the fence is critical. Of course, it's a matter of choice at the end of the day. So if one has the flair to argue at the bar, by all means, go for it.
Thanks. Aneesh?
Yeah, I think there's not much more to add. because I must say, like, I work with a senior counsel, and I think by far it was the most challenging thing that I've done in my career. And working for a prolific senior did not make life easy at all. And Dr. Singhvi's chamber is a fairly busy chamber, and he's a very, very hard taskmaster. So that time was definitely difficult and challenging. But I learned a lot. But in terms of advice, I think what I want to add to, apart from everything that Sajan sir, ma'am, and Boski have said, is very early on. I think professionals very early on must join either a smaller practice or a law firm or a counsel, and not necessarily start with a senior, because that exposure of drafting and filing and working on trials is, I think, an essential exposure that lawyers miss. When they're if they start their career with a senior advocate like I did, I think that's the one thing that I would change if I could go back in time and change. The other thing I want to say, I think Sajan sir rightly said that, in litigation, there is no money in the beginning, and, there is so much money at the end of the rainbow that you wouldn't know what to do. But also, I think one other thing about litigation is, I think the two words sort of work-life balance and litigation are just do not go well at all. If your idea is to have a great work-life balance and be a litigator, I do not think you're cut out to litigate, because when you're not in court or you're not preparing to be in court the next day, you must sort of be, spending time reading judgments. It's much like the medical profession. It's changing on a day-to-day basis. A position of law that was true yesterday will not be true today. So if you're not aware of it, if you're not abreast of it, you will not know it. So as a litigator, the onus lies on yourself to sort of to spend that time. And if you think that you're going to have work-life balance outside of court, spending reading judgments or reading jurisprudence as it is. So that is something that is very, very crucial, that young lawyers must know, that in the first few years of litigation, it's going to be really, really hard work. It's going to be long hours. It's going to be tough. And if you can stick that out, I think the money and the comfort will follow. That's I think the only thing that I would add.
Thanks, Aneesh. Very encouraging. Before I go on with the questions, I see that there are some raised hands amongst the participants. Can you please type your questions onto the chat box? And after we sort of run through a few questions, which I think will be of common interest, we'll take questions from the participants. So if you can just type it in, we'll take them up as we move on. Boski, I'd like to come to your 360-degree point. That sort of defines your role. So how do you manage these expectations? You have the management who expects something from a case. You have other functions in the company, say tax or competition or, the product who have expectations. And then you also have the external counsel that you go to. So how do you deal with all of this?
Chitra, I'll definitely say that I've never been more excited about what I do. The best part about being an in-house counsel is that on a given day, I could be handling a contract, I could be negotiating with a counterparty. On one day I'm handling employment and labor-related disputes in a jurisdiction. On another day, you're handling a product launch in a city which is probably hostile. So, an in-house counsel's role is to it really goes beyond being the bridge between the requirements of the business and the pressures of the board. The board has, their own independent pressures, and you're not only looking at the legal aspect of it. So you're not necessarily a good lawyer. That's a given. I mean, that's what's going to be expected from our college graduates and practicing lawyers. That there's going to be little time to turn around with your answers. You're moving in a fast-paced environment. Everything is competitive and cutthroat. So one really has to move beyond expectations. And that is when it's really key to understand your business at deeper granular levels. And that can happen only by having more and more conversations, by having, having clear communications, by not being afraid to ask questions. So say, for instance, where I'm dealing with the board, one has to be extremely mindful of what is your purpose, or what is the clarity, why are we doing what we are doing, and most essential and critical is speed. What's happening in, say, California today is going to impact India. So we start having conversations around it. So it's really way beyond a traditional lawyer's role. It's exciting, it's unnerving sometimes. We don't have answers sometimes. So there's a lot of teamwork and collaboration that goes into it. One has to work like a well-oiled machine, one screw missing here or there, and there could be friction, and there could be serious consequences on the company. So I think an in-house counsel's role is extremely critical on that front.
Thanks, Boski. Poornima, how do you manage a client's expectations when a case comes to you? In terms of remedies, in terms of reliefs, in terms of routes to a particular outcome?
So I think you must understand who your client is and what they want. And that's key to any advice you give them. And as we've grown as lawyers and people who work with the law, I've realized it's not only about the law. And for the client, particularly in a commercial practice, it's a lot about the business. So often when I give it to first-year lawyers or second-year lawyers, I get a wonderful treatise of the law. And at the end, they tell you that this won't work. The client has no case. But it is your problem as counsel or whoever the client is approaching to find a solution. Right? They don't want to go to court. And oftentimes I see counsel who come to me and say, they've gone to 3 lawyers and all of them have said, let's go to court and fight this. But that's not what the client wants. And that's not your first solution, right? The client wants a solution to a problem. And you must find that solution or do the best that you can. And if there is obviously no way out, well, then there's no way out. But do your best to see how you can try provide a solution to the client. You must understand who your client is. That's the first thing that I always tell young lawyers who work with me, and then they go back, they relook at the law, they re-understand what the client wants. Get to know your client. That's the second thing. Whoever your client is, understand who they are. They're a large corporation. Do they have international practices? Or is it an individual, to whom, this piece of property matters more than anything else? So whatever it is, once you know your client, you can then advise them accordingly and see where that's going. Obviously, if you worked with a client for over a period of time, you get to know them well, and many of them become your friends, and you get more attuned to how they want, their disputes resolved. But to many large corporations, a big dispute probably occurs once in 10 years or once maybe in 20 years. So once and they're not going to come to you every day. So, then it is very, very important how you resolve that dispute for them or what you advise them to go about it. So take a full perspective from, the business to the law to, what the client wants, and then advise them. So just don't jump to the law alone as the solution.
That's useful. Sajan, what has practice been like? I mean, you have been the Additional Advocate General, which means that there is a particular perspective you bring to how you would argue or look at disputes or a challenge. You've also handled cases that have an immediate client. So, when that the outcome is not just you and your client, the outcome is many, many people. In the case of the 377 challenge, I mean, it's such a basic fundamental right that you were arguing for. How do these aspects sort of impact or work in the way you deal with disputes or take up a case or manage a case?
Again, as I said, I don't think there is the method by which you can actually walk the path in this profession. I don't think you can succeed by design, simply because Palkiwala did certain things. I can't say I will do exactly what he did over a period of time and I will become Palkiwala. that I don't think works. It's not that you go to Aden and start fueling cars in a petrol station in Aden. At some point of time, you will be a Reliance and you will control the petrochemical market in the world. That doesn't happen that way. And similarly, in our practice, I don't think you have the beaten path by which you can check boxes. And the youngsters in this webinar must be clear in their head that there aren't boxes to check in terms of what you should or should not do to succeed in this profession, particularly as a litigator. But to answer the question, Chitra, what is expected? I think, yes, working for multi-dimensional clients actually makes you a mature lawyer. I, for one, have always been a corporate / communications lawyer for a good part of my life until I moved on to the state side and kind of became the government's lawyer or the state's lawyer, so to speak. And that actually changed the entire perspective of what you can bring to the table as a counsel. A few things that we should always remember is, one, we have to be true to ourselves in terms of the brief. We have to make sure that we identify the brief, identify the pitfalls in it, identify the benefits in it, and portray it in as many forms and dimensions to court. Not portray a particular dimension. So I think a successful lawyer actually brings a multi-dimensional approach to a single brief. And that is actually what leads to an ultimate victory in court. Two, it is a constant evolution process for lawyers. 24 years, 1996 is when I enrolled and started practice, a few months with a senior. And then I started litigating in the trial courts in Bangalore, the city civil court, not just the city civil court, the magistrates court. My first few months were actually simply moving bail petitions for NDPS cases. People would be caught with narcotic and psychotropic substances in their pockets, and I would actually get bail for them. And that's how I earned my living. And I'm proud of that fact. The fact that I did criminal law as a career avocation for some part of my life, I think changed me as a lawyer. But kindly see, from 1996 to now, when I started at the bar, many practice areas didn't exist. Information technology law was unknown. Even computer law was not known. So information technology law as a practice vertical which I thrive in today, did not exist when I started my career. Please look at insolvency law. All that we knew was the Presidency Towns Insolvency Act, which meant nothing. Now today we have an insolvency law practice which is vibrant. Please look at competition law. There was little or nothing of competition law in the mid-90s. Today we have a vibrant competition law practice. Please look at electricity. Boski has done so much work on the electricity side. There was nothing called electricity law. There was one Electricity Act, Regulatory Act, which meant again nothing. Today you have a separate domain of practice on electricity law. We were just speaking on flue gas desulfurization, which is a combination of environmental law and electricity law coming together for possibly one of the largest litigations that the country has seen. Look at airport regulations. When we started our career, we flew out of tin sheds and flew into tin sheds from city to city. Today you have an airport regulatory practice with an airport regulatory appellate tribunal sitting down and seeing what sort of multi-year tariff must be fixed for airports and what is that attained you should pay. Now, in 1995-96, if somebody had told me this, I would have said, what has law got to do with it? But the fact is, law has got everything to do with it. Practice of the law has everything to do with it today. And therefore, there is that evolution. We should always remember, and this is one statement I will always remember. I think it's Anne Gilligan who said that there is nothing in a caterpillar which tells you that one day it will become a butterfly. And that's so about the law. It may be a very drab subject when you start reading it, but you never know how it will pan out to being possibly the foremost in terms of practice verticals over a period of time. I think for me, the lessons I have learned are the following. Does not matter which court you are in. It does not matter whether I am before the magistrate asking for bail in an NDPS matter or before a 9-judge bench fighting for privacy or fighting for manifestations of Aadhaar in some form or the other, or fighting for a particular financial regulation from the Reserve Bank on whether it should or should not apply. It does not matter which court it is. It does not matter how large your brief is. It does not matter how weighty or how many lawyers are involved in the brief and how much money is chasing that brief. What matters is, what is that you bring to that brief? You have to bring that one extra mile onto that brief which others are not bringing in, which only comes with two factors. One, constant reading, to read and reread the brief. Everyone can read the brief as it is, but very few people can read it to identify the gaps in that brief. Now, to identify the gap in the brief, you need to read the brief upside down, downside up, whatever it takes. Second, to actually be convinced that your brief has a particular element which you can highlight. Unless you can figure out that one difference, if you can't remove that one ruby from out of the haystack, there is little or nothing that you contribute to the legal profession as a litigator. So I think for any student of the law who has a keen sense and the commitment to read and put in the hard work, then you don't need intelligence. Please forget about the fact that you are not a second or third generation lawyer, or you are not one of those brilliant fellows in your class. Does not matter. What matters is hard work. What matters is commitment. And what matters is repeat exercise of reading and rereading to identify that one little thing which you can make as a difference. I think if that is followed, I can't think of any litigator in this country who has done badly or who has not succeeded despite hard work. I can name hundreds of them who have not succeeded because although they are extremely smart, they have not put in the work that is required. But I can't identify even one lawyer who is possibly subordinary in terms of intelligence levels, but has done extremely well simply because of hard work. And that, I think, is the essence of this profession.
Thanks, Sajan. Both you and Aneesh have made the point about hard work being the decisive sort of input that lawyers need to put in, particularly in the early years. Aneesh, Boski and Sajan were talking about the trial experience and how important it was. You graduated from college and moved into possibly a very big office in terms of the intensity of the cases, the magnitude of the cases that were taken up in that office. And this was before the Supreme Court, the last sort of court of call. How was that? What was that experience like?
So immediately, sort of, it was definitely a fish out of water. So I had no idea what I was doing. I had absolutely no idea what I was getting myself into. The only thing that sort of kept me going was, I think, two things. I find that the profession is extraordinarily supportive. And I think what Sajan sir has said is extremely right. If you are willing to put in the hard work, people around you will notice that and will help you as you come along. So when I first joined the chamber, and Dr. Singh's chamber, notoriously as busy as it is also a really, really small chamber. I mean, he at any given point in time used to only have maybe 5 or 6 juniors for about 15 or 20 matters in court. So on a day-to-day basis, which would average about 2 to 3 briefs per junior. Which meant that when I came in, I was handed over briefs and I did not know what to do with those briefs and how to make the briefs in a particular way. I have had the pleasure of working with Sajan sir when he was managing partner of a firm, and he would tell me that, listen, this is what he wants, or this is what he needs to be, this is what he needs get done, and that would get done. I would work at it to get it done. But like I said, if without the support of my chambermates or counsel that would come into the chamber, I would have found it very, very, very hard. And like I said in the beginning, I think that lacking that experience of drafting and not having seen trial work, I think really did harm me a little bit in the beginning, and that was certainly something that I realized that I should have sort of changed. If I could have changed it, I would have. And the hard work. I mean, the hours were just incessant because we finished court at about 4:30 in the afternoon, which is the time that you come back and start preparing for the next day's brief. So when you start working at 5 in the evening, you can't go home at 7. There is no 7 p.m. I'm now done with work. That's not the case. 7 p.m. is probably when briefing counsels would come to brief us. And then you would start working on the brief after that, and then you'd work till about 12:31 in the night on an everyday basis. And Saturdays and Sundays used to be our busiest days because Mondays used to be the busiest day in the Supreme Court. So we used to be in office all day on a Saturday and a Sunday. So it was mind-boggling in terms of the amount of time that you had to spend in office. And I frankly realized 3 years down the line, and I was looking through the questions some people had had asked me the same question, that after about a few years of doing that, I looked back at my own life and realized this is not for me. And when I arrived at that reality, I decided to step away. Right. So that reality check is very, very important. And you can't be a successful litigator and not work hard. That doesn't work. You could be extraordinarily brilliant, like Sajan sir said, but it won't. I mean, it will only get you so far and not further. And yeah, hard work and the will to stick to it, which I did not have, but the will to stick to it is vital.
Now, I must on a lighter side say something. Aneesh is very, very modest when he said that, that I, in my previous avatar before my designation, would go and, tell Aneesh what we need to do. That was not the case. In my previous avatar, when I was not designated and we had to brief Dr. Singhvi on some huge matter from Bangalore, we'd carry all our bags on our heads and, like this village boys, we would land up in this chamber and Dr. Singhvi would have no time for you. And therefore, all of us would sit together and brief Aneesh. And therefore, he was our counsel. We would then spend hours briefing him and with the hope that he can, brief Dr. Singhvi and he'll be ready for the next day. So Aneesh was really the guru. Although younger in age, he was the guru for us.
Now we know who chased Aneesh out of
yes, possibly.
I agree. I do agree.
Sajan, let me hold you. How you did?
Both are very modest when it comes to hard work. I must say, Sajan sir was reading my brief at 6 a.m. in the morning when we had a final hearing in Supreme Court. So if he can work that hard at his age, the younger generation really has no excuse.
Are we telling our listeners that the only time you have to yourself is from 1:30 a.m. in the morning to 5:30?
That's the best
time. You don't have that too. I think for a lawyer, sorry, I'll just one sentence. I think if you really want to become a good litigator, let me put it this way: you have to be a little greedy. You have to say that, okay, I'm going to give up my time because I'm going to make some money at some point of time. So it's saying that greed is not a bad thing. Let me tell you, don't be greedy just to chase money, but you need to have that greed to say that I need to go to the next level. I want to get there. If you don't do that, this profession, of course, feeds everybody. It's a very egalitarian profession. People earn money at all levels. It's a multi-storied building. The ground floor is kind of crowded. The top floors are empty, and therefore, for you to get onto those top floors, you need to have that little bit of madness. Push yourself. Call it greed, call it conviction, call it commitment, call it what you will. But you need to do that. If you don't do that, you will just not climb the ladder.
Yeah, there is also the adrenaline of working to to a level of preparedness that keeps you up and keeps you going. I think that's very much a part of disputes practice. So Sajan, how have things changed? You did talk about niche practices, but on a day-to-day basis, how have things changed since the 1990s to now in litigation? What were your expectations then of the profession? What has changed?
Oh, enormously. And I must say, people like me have actually been extremely, extremely lucky to have started our careers at the cusp of change in the profession in this country. Chitra, you'll remember, we studied at a point of time when computers didn't exist. We studied law at a point of time when the internet did not exist. Our research meant, multiple digests over multiple years and making notes by hand and then collating those notes, keeping a big register which will have A to Z, marked out in pages, and writing decisions alphabetically and keeping them as a ready reckoner if you need to use them at some point of time in court. Now, from that, I remember, typing out plaints with manifold paper and carbon papers, 1:5, 1:6, and because I was the junior most, I would get the 6th copy, which you just can't read, but you're expected to read and brief somebody. And I remember the fact that sending a fax message was actually a privilege. Otherwise, you had to put it in speed post or in courier and wait for 2 days for the draft to come back for you to finalize it and file. Now, that was the pace at which we started our careers. And therefore, we had all the time, so to speak, compared to today, in terms of preparing our briefs, seeing what will be filed, what will not be filed. Research meant 3 or 4 days of researching on a particular aspect. Now, that entire thing is compressed today. Today, research is at the fingertip. The information technology has changed the way you look at legal research, number one. Number two, technology has become all pervasive in the way you draft, in the way you file, and therefore the time that is given to you for a brief has become smaller and smaller. You compress yourself within that time frame, but the work product has become better. What you generated with 10 days of work, let us say in the mid 90s, is possibly worse than what we generate with a day's work of research and a day's work of mental aptitude, so to speak, on a brief today. And therefore the profession has that way changed. The thresholds of excellence are far higher, but you have the tools to achieve that excellence. And therefore, if I can put it in other words, all of us started on a journey and we took the right steps, but we did not have the right shoes. And today, actually, the profession gives you the right shoes on day one. You come from brilliant institutions. Institutions teach you where to research the law. At our points of time, courtesy law school, we learned something, but most law colleges did not teach you where to even look for the law. How is that you should even look at a brief? How should you deal with a brief? None of that was taught to you. But those things are taught one today. Second, and as Aneesh rightly said, I believe the bar has become far more inclusive today than it was 25 years or 30 years ago. And the bar is inclusive, not just from a perspective of people who don't belong to the profession, that is first generation lawyers coming in, etc. It has also become very inclusive in terms of not having the gender bias that we had 25, 30 years ago. There was, when I joined the bar in Karnataka and I saw how Delhi worked then, there was a distinct gender bias. There was a scenario where you are expected to be a good lawyer only if you belong to a particular chamber, if you are a male, and those things existed. But come to look at it today, gender bias literally has vanished. Today, we have far more capable lawyers who are from the female gender than we have in terms of men. And that's a matter of pride for us in the bar, number one. Number two, I have not found, and I'm not saying so simply because I'm a senior advocate today, I have not found in recent times that a court looks at a male lawyer and a female lawyer differently when it comes to an argument. Absolutely not. And therefore, those are welcome changes that have occurred. And I would think the youngsters, therefore, wanting to join the profession should make the best of it. The third thing which has changed, and I'll stop with that, is it's all not correct to say that there is no money in the legal profession when it comes to litigation. When I started my career, I was paid 1,200 rupees, and that was a princely sum because my contemporaries were paid 500 rupees. Now, simply because my senior took a liking to me, etc., I got 1,200 rupees. But 1,200 rupees really was not enough to feed me and fuel my vehicle and possibly manage my rent. It was just not enough. But that's not the case today. Any self-respecting senior advocate or a large practitioner who brings juniors onto the chamber pays well enough to sustain at least. And therefore, that has changed. There is enough money to start with in the profession. And I would therefore urge that a lot more people continue at the bar rather than moving away. And you never know where that shift occurs. Sometimes the best of brains move away from the bar because of other indicators, maybe financial, etc. In the process, the bar suffers. Therefore, I would always urge the youngsters to stay as long as they can and then see how that shift actually takes on. As I said, there is nothing in a caterpillar which tells you that one day it will become a butterfly.
Can Boski and I'm sorry about the noise. I'll just wait for a minute. Yeah. Boski and Poornima, if you can both weigh in on the aspects of gender. How have things changed for women? Would you agree with Sajan? And secondly, in your individual, pathways as in-house counsel or as a partner in a law firm, what are the changes that have taken place along the way? Who can I ask Boski to go first?
Yeah, sure. Thank you, Chitra. It's an extremely important question, and I think that's going to put certain things in perspective so far as the role of an in-house counsel is concerned. I'm sure all our listeners here know that in-house legal counsels are no longer mere advisors to the board, we are all hearing words like business enablers, partners, people who will propel the vision of the company on a going forward basis. So what's extremely important is just coming back to the 360-degree conversation that we were having. As an in-house counsel, if you do not know the nitty-gritty and granular details of your business, you're never going to be able to communicate it well to, for instance, if I was to brief Sajan sir on a matter, the biggest challenge that in-house counsels face today is the business speaks an entirely different language and the lawyers speak an entirely different language. And that's when in-house persons work as a conduit to convey the actual pain points of a client to senior counsels. I'll definitely say that gone are the days when in-house persons were in an extremely reactive role. You would receive a court summons or you'd receive a show cause notice, and that's when older in-house counsels would pack up their brief and go to the best law firms in the town for advice. Today we have we've become the primary advisors to the board. So one has to think from a strategic perspective. One really has to think whether we must go into this dispute or no. Each one of us has to choose our battles wisely. I mean, no organization at Uber, we are at the receiving end of consumer cases where an unhappy customer will slap a notice of, say, 50 rupees or 100 rupees. So you really have to choose what kind of battles you want to get into. Another most important color of an in-house counsel's role is policy advocacy. Unfortunately, colleges don't teach policy advocacy, and I'm really happy that we have well-known institutes like Daksha today that are having courses around it. We didn't have the privilege back then. So younger listeners today have, like Sajan sir rightly said, you have so many tools at your disposal. You have resources. Research softwares, artificial intelligence has crept into each layer of our practice. So I definitely say that we need to leverage that. And at the same time, an in-house counsel has to be the voice of conscience before the board. Aneesh and I were discussing on an issue the other day, and we were really talking about how do you say no to a board? And my answer to him was that it's probably the easiest to say no. But that's not what they want to hear. Our business development colleagues are most unhappy when lawyers say that you cannot do this and you cannot do that. So that is when you have to, apply your skill sets and see how you can bring about a balance between, risk management. How do you comply with the law? And at the same time, how do you also keep businesses running? Sometimes your management is going to be unhappy about no as an answer, but you have to prevail on the board and try to look at innovative ways as to how do you change the narrative. So I think it's extremely important. How do you articulate things? And I cannot overemphasize the importance and the need to be clear in your communication. One really needs to know, like Poornima rightly said, you need to be aware of what are your clients' needs. So, and one of my favorite models that we apply while dealing with our internal stakeholders or while dealing with external counsels is, the AIM model. That's the audience intent and message model. There's never going to be a straight-jacketed formula. Horses for courses, as they say. So you really have to see who your audience is. What is the intent that you're going to deliver? If I'm interacting with a senior counsel, there is a certain way that there's a language that we speak. But when you're talking to business people, there is a language that you have to understand yourself, and that means one has to learn and unlearn. For instance, when I started my work at Uber and I wrote one long, detailed email with all supporting case laws, and my managing director wrote back to me saying, what is the TLDR? And I had absolutely no clue what does TLDR mean. And then I had to go and Google, and the answer was like, okay, what is the too long, didn't read? So what's also extremely critical, Chitra, in my opinion, is that time is no longer a luxury. So one, an audience, to capture audience attention, one really needs to know what is it that you need to convey, and there is only this much time. Time is not infinite. So how do you convey it best to get your desired result is the most important role of an in-house counsel. And speaking of gender biases, I think that's going to need an entirely different session. Definitely from my side of the story, because like I said, for me, the fight started much early on, and I've experienced my own. I've had my own share of unpleasant experiences speaking about gender biases. Sir spoke about gender, but I've also seen caste biases and age biases. When you're working, whether you're working as an in-house counselor or whether you're a woman advocate at the bar, judges, there are times when judges don't take you seriously, maybe because you don't look your age, or we've also had remarks being passed such as, why don't you send your senior? So yes, there are going to be biases, but what I am going to tell my young listeners is that please do not let that bog you down. Please do not move from your path. Don't let these external voices distract you. If you've decided to walk this path, give it what it takes, and please be patient. You may or may not get results, but you're definitely going to be contributing to a much larger cause. And from my part, whatever the endeavor is to do whatever I can, and leave the rest to our progressive men and women to support us. So yes, things are changing slowly but surely.
Thanks, Boski. Poornima, how are things changing in the law firm? Are men changing in the profession? Tell us.
So, Chitra, obviously, books can be written on both these subjects, but I'll try and see how we can talk a little bit about both, right? So, law firms, I think there are all sorts of law firms, right? You can't compartmentalize and say this is a typical law firm. So, to me, as I said, the camaraderie of my partners is the greatest asset of my law firm, and I don't see dispute resolution earning money as the end game here. For me, through dispute resolution, you engage with society. We are more generalist as dispute counsel than, say, M&A folk or capital markets or whoever else, right? I mean, ask any dispute resolution lawyer, even though they may not be a criminal lawyer. Somebody will call you and say, I've got the cops knocking on my door, what should I do? And they'll still have some answer that, whereas, a very, very specialized capital markets lawyer may not have an answer to that. They'll say, call a criminal lawyer, right? So I think that's the greatest asset for me. It gives you a true insight into society. And when you go to court, you will see the poorest person and the richest person. And they're true levelers in that sense, right? And you may have the most fantastic documents drafted in, New York or London, and if they're going to be litigated before the city civil court in Bangalore, you've got to explain that to the judge there, and he may not have that worldview, right? So, and that therein lies, your expertise in bringing the world down to where it finally has to be resolved, the dispute. So I think law firms bring that expertise together. There are also places where you have each other's backs. Like I told you, I'm not in Bangalore. I'm somewhere else on the presumption that we could all be doing e-court hearings, and we had 3 hearings today. But one video conference facility failed in Bangalore, and somebody had to rush to court. And I had a partner in Bangalore who could pick up the brief and say, I'll do it for you. If I were a single solo practitioner, that wouldn't have happened, right? And we do it for each other. So I think that sort of helps me be in a law firm. Law firms to me have also become places, connecting to the other query on gender, are places where, the gender bias is significantly lesser. Of course, you choose where you want to work. And I think that has really helped push women forward and more egalitarian. The bias in sort of, we still have fewer women senior counsel. We still have fewer women judges. So it's very much existent, and fewer women want to get into litigation. You can see it when as you grow older, as you become mothers, as you have greater caregiving capacities, you find that women have equal responsibility than whoever you choose as your partners. The court list comes out very late at night. So you have to be in a house which is progressive. You have to be a privileged woman, and I am very, very privileged and conscious of my privilege. But I can sort of hand over my child to my husband or my nanny and say, I'm going to go off and brief counsel at 10 p.m. at night. Nobody would question. But that is not the average Indian woman, right? I've called senior counsel in every part of the country and said, so I'm coming at 10 p.m. after I put my child to sleep. They're fine with that, because some of them work late. And those who don't work late, I say, I want the 6 p.m. slot so I can be back home for dinner with my son. But that flexibility doesn't exist with everybody. And people outside the law just don't appreciate and understand that, right? My parents-in-law have never asked that, but I can see sometimes my mom asking me, hey, and my mom's a lawyer too. She's like, can you wrap it up quickly? No, maybe you can't. And the point is that you can't, right? So, and so you put your children to sleep and then you get back to your computers and things like that. So it is very much a structural bias. We could all have weekly lists. We could know when our lists are coming out. So we could all plan our lives better, but it doesn't exist. It just, a simple solution doesn't exist. So there's a huge structural bias, conscious or unconscious, that works against women. Second, I still see that, let's take the issue of appointment of arbitrators and mediators. Men are still preferred. I don't see the issue in choosing me as a law firm partner to advise any sort of big corporation or anybody else. But in terms of choosing you as an arbitrator and mediator, I can see the hesitation, right? They question your capability a lot more. If you were a retired judge who were male, you would be getting it very, very easily. If you were an elderly gentleman, that would be much easier. So it's not just a question of your own capability, but it's a question of where you come from, what language you speak, what words you use. So it very much exists, and we're still sort of fighting that bias. And as Boski said, we must fight it because people have fought and made my life easier, and I have decided to make sure that I make other people's life easier. But here's my advice: tap into the profession. The profession does help. Choose mentors. Often very young lawyers write to me and say, "Ma'am, we just want to talk to you about something." Right? Be it from sexual harassment at the workplace to just random remarks passed. It just helps to have a conversation. So pick your mentors, talk to them, build your networks, draw strength from each other. Sometimes you would just meet for lunch, once a month, a group of people, just to say, how would you deal with this situation? It helps further. So you have to draw strength from each other. And to be in the profession, you must love the law. You must believe in the law. And you must also believe that law will help society change in whatever manner, whether it's commercial law, whether it's public law. I have friends who work for the Alternate Law Forum, which is a group of lawyers in Bangalore. Tremendously inspiring. The fact that they can do this with no money, day in and day out, work hard, just to make sure that somebody else's civil liberties are protected. I think that's tremendous, right? I do some part of pro bono work, but that is truly outstanding. So pick and do what you love to do. If you don't think the law is for you, that's absolutely fine. We all have friends who've decided they don't want to do the law and gone on to do other things. So no shame in that. So you must love the law. I've seen a lot of questions on work-life balance, and some of them have been addressed to me. So I'll pick that one topic. I know we're running out of time. So a few years we went to the National Law School for recruitment. And you have these RCC talks before you actually sit in for recruitment. And we were asked, Harish and I, who, are the partner, we've heard that your firm has good work-life balance. Does that mean we will not have to work on any weekends? We were shocked. We work all weekends, all of us. We work on holidays. We work all the time. Work-life balance means I am not going to keep you in office with no work, right? There was a time when people felt that they had to stay in offices when they had nothing to do. No, if you have nothing to do, go home. But technology allows you now to work from wherever else in the world. So if you're saying when you have work, you want to do it, but I will have to do it for you. No, this is not your profession, right? Find something else that works for you. So work-life balance in law firms is there simply because you have each other's back. But if you then become the person who has not have anybody else's back, then they will ask you to leave. That's the only way out. You have to be there for each other. If there is a crisis, somebody will step up, will help you. If you want another interpretation on the law, you can pick up the phone and somebody will say, yes, but I don't think this works. Something else will work better. This has worked for us in Delhi. Maybe it will work in Bangalore, in Chennai. This is not working. what's your view? So I think that's great camaraderie, and that will help, and that may help in terms of your research, WhatsApp groups or whatever else have you. Well, and Sajan talked about how fast we're researching things. So all of those things help in getting your work a little better. But if you want to make sure you're going to get all your Saturdays off, no, dispute resolution is not for you, is all I have to say. And there's no shame in that, pick what works for you. So just be clear that, yeah, hard work is very important. Whether or not you want the money or don't want the money, hard work still is important, right? So you may choose you don't want the money, or you may choose, you're happy with the second story that Sajan mentioned, or you want to go to the top story. But, you have to earn the respect of your peers. And for that, hard work is very, very important. I think these are all nuggets of all the various issues that we've covered. But maybe, Daksha could organize another one on gender, and Boski and I would be happy to weigh in on that. Thank you.
I'd love to be a part of that. There's just so much to talk about. A little point, Chitra, if you allow me, that I'd like to add to what Poornima has said is, we're talking about progressive laws, and today we're talking about sexual harassment, we're talking about maternity benefits. And, but as we speak today, we have companies that are willingly and happily offering period leaves. So, if the conversation has moved to that end of the spectrum, women lawyers definitely have nothing to fear. In-house corporations, homegrown organizations, or multinational corporations for that matter, have absolutely sensitive and, much need of the hour policies in place. And we really need to believe that you are working in safe atmospheres, and the policies will be implemented, god forbid, but if the time comes, the policies will be implemented without any element of bias. So there's nothing stopping women today, and we're often listening to these words, gender diversity and inclusion. It's become a burning topic in boardrooms, coffee tables, and college campuses. But what I really want to add is that be so good at your job that the sound of this gender bias sort of dies down, amidst the recognition that your work gets. And the only way to, like Sajan and Aneesh and Poornima have repeatedly said, that if you want to excel, there is no substitute to hard work. So if anyone out there believes that you're going to come in-house and going to have the perfect work-life balance, I'm really sorry to break your bubble. It's a myth. So yes, we do have Saturdays and Sundays off, but today we are all working in real time. You're working across time zones. There are times when we have to wake up at 6 a.m. in the morning, and last night I wrapped up a call at 1 a.m. where we have the all hands, where you try to tune in into what are the next steps for the next quarter. So if you want to work with global organizations, or even homegrown organizations that are desperate to make a mark for themselves, there's work-life balances. That expectation is just going to leave you all disappointed. So, I guess take your pick.
Thanks. I think Sajan, Poornima, Boski, you all have weighed in on aspects in this profession, on lineage, on gender, on age, and your exhortation that we should push forward. Very, very important. Thank you. Aneesh, what will our listeners, what can they expect in terms of, what law firms want when they're recruiting young lawyers, or what companies, expect when they're recruiting young lawyers? And keeping with what's been discussed till now, what are the disadvantages women face?
So, Chitra, I think thanks for asking, because I was going to pipe up and speak anyway. I think, primarily, I feel that now, and I want a disagreement or an agreement from Sajan and Poornima ma'am. I feel that more and more people are opting for litigation as their first choice. In their respective batches, I would have felt that they would have had fewer people opting for litigation as their primary choice and would like to work with firms as corporate lawyers. But now I feel, even with the top law schools, more and more students are choosing to join the profession rather than joining, with a firm or as a practitioner, whichever way, but are choosing litigation as their primary choice. I think the biggest development that I've seen on the in-house side as well is that in-house counsels are getting more specialized. So more and more in-house counsel are sort of hiring specialist lawyers for specialist practices. So we've seen the trend that now in-house corporates are hiring heads of litigation. So somebody who has practiced for a while and is moving in-house to manage the corporate, the business's litigation requirements, and they need that specialist. Boski is an example. So we are seeing that trend sort of switch even within the law firm space. I've been with Vahura now almost 7 years plus, and uh, when I first started here, initially the conversation would be on the litigation side. The conversation would be, Aneesh, we just want to hire bodies, people to just go to court and just man the brief. Today, the conversation has completely changed. Litigation is a primary driver of practice within the firm space. It is a primary earner for the law firms as well, which means that the law firm partners do want all their team members to be value additions and contributors to that practice. At the junior level, they want people to do excellent research. At the mid level, they're drafting and filing. Those skills should be top of the draw. By the time they become sort of mid-senior, they must manage strategy, must manage external relationship, whereas the partner is sort of focused on sort of managing the client. And that, that makes a team, and that the partner is looking for that team. So when we are also hiring, that's what the partner is asking us, somebody who's very clear that basics about litigation are correct. They want to be a litigator. They like the profession. They want to be in the law field, and that's what they want to hire. Another trend, and the big trend that we are seeing now, is more and more law firms are open to their lawyers arguing their own briefs. The reliance on senior advocates is not as high as it was a few years ago. The smaller matters, the procedural hearings are being managed by the lawyers themselves, by the partners, by the team members, which means that primarily the firm lawyers are getting the option and the chance to be advocates. They are no longer mere solicitors, and that change is it's very definite, it's very evident, which means that it bodes a great sort of future for the profession. And just on the gender side, I think while I agree that I think the profession is doing more than it was in the past, but I feel that we can certainly do more. When you see typical law firms hire at the junior most level, you would see almost a 50-50 mix of men and women. But at the senior levels, at the partner levels, at the senior advocate level, at the judges level, this percentage drastically drops, in which sort of still points to the fact that we have structural or other biases that lead to gender unequal positions at the senior most at the top echelons of the bar, and that needs to change. For whatever reason, if women are taking a break, I mean, Vahura has an initiative which is called Relaunch. We help women who have taken a break to come back to practice. Similarly, I feel that if clients and other institutions could take that initiative to bring women back into workplace and reintegrate, I think we could do much more than we're doing today.
Thanks, Aneesh. We'll go to the questions that the participants have asked. Sajan, I'm going to two questions for you. The first is, with online hearings, can we expect a better work-life balance? There is another participant who is looking at starting independent practice now. Any advice for him?
Okay, online hearing, I think, has been a mixed bag. And if you ask me personally, I've been a great votary of online hearings. It has certainly made life far more structured and easier for counsel. And therefore, if you ask me, have online hearings therefore made life better? Answer is yes. Has it improved work-life balance? Answer is no. You have just filled in the extra time that you have with more briefs. That's all it is. So therefore, this whole concept of work-life balance, I should really tell the youngsters that forget about that concept. It doesn't exist in this profession. And I genuinely think that you should not really be asking for it in this profession. There is no concept of work and life which are two distinct parts of a lawyer. Absolutely not. Once you get into this profession, your work is your life. You are actually building your systems around your work, as Poornima rightly said, and I can well see it's far more difficult for a lady as compared to a gentleman in the profession. But we all build our lives around our profession. We build our lives around our briefs. We build our lives around our senior advocates. We build our lives around our partners. We build our lives around what the courts do. We sometimes provide efficiency to an inefficient system which exists in a court. Simply because, as Poornima said, the list comes out at 7 o'clock or 10 o'clock in the night. We build our lives around it to work at 12 o'clock in the night. So work-life balance, forget about that concept. Yes, virtual hearings have made life far easier for lawyers. For example, today, I appeared in 3 different high courts and the Supreme Court, all sitting out of my desk. It would not have been possible in a physical setting because I would have gone on to one high court and that would be the end of the day for me. I had to then move adjournments in other courts to saying that I am not available, I'm out of town, hear me on another day. So that's one. Second, in terms of starting off, I have one bit of experience I can share with whoever this youngster is, lady, gentleman, I don't know who wants to really start off. There is no right time to start off independent in this practice. I started off an independent practice with 3 months in the bar. And when I did so, people called me a fool. But it worked brilliantly for me. End of 3 months, I had set up a chamber. I had one desk, one secretary and one clerk and no briefs. And the entire year, I sat down hoping to receive one brief or the other. And my annual billing for that year was 18,200 rupees. And I'm proud of that fact that I billed 18,200 rupees over the whole year. I don't know how I survived, but I did. And therefore, if you believe you should start on your own, please jump and start on your own. Today is the day, not even tomorrow. It is, of course, going to be a difficult journey because when you start on your own, the trappings of comfort that a larger office gives you will not exist, number one. But the benefit is you will start taking decisions for which you and only you are responsible. And therefore, automatically, you increase the threshold of your decision-making process to a scenario where you will not be wrong. And that threshold comes in only when you make those decisions. It will never happen when you're in a larger setup and there are 20 people who are actually sitting together to make those decisions. So as a litigator, it is important that you go on your own. It's important that you burn your fingers. It's important that you learn on the job. And if you believe you are ready for it, do it today than tomorrow. The best time to plant a tree was 10 years ago. The second best time to plant a tree is today. And therefore, that's what you should do in this profession.
Thanks, Sajan. I'm going to pick up some questions, but I'd urge the panelists to pick on questions that they think they'd like to respond to and to, just sort of pitch in.
Chitra, I've just looked at a few. If you don't mind,
please,
I'll go while you look
go
through the others.
Go ahead.
So there was a question on mediation, and Chitra, you're also in the space. Yeah. I think mediation is truly evolving rapidly in India, but there's a lot more work to do. And there's a group of people who are working very closely on and exploring whether we need a mediation legislation in India. Mediation continues to be highly successful, even at the court annex centers. I think we have, depending on which court center we're looking at, between 70 to 80% of a success rate. But are parties actively going into mediation? Yes and no. And it depends a lot on who's advising them. And I know sometimes I do push people into mediation and tell them, look, this is how the court situation is going to work out. This is a mediation, give it a shot. Let's see what happens. Sometimes they bite, sometimes they don't. And it also depends on what's happening on the other side. So these are sort of an evolving area. But I think if you're interested, it's good to stay in touch and dabble in the area. But I don't think it's reached a stage where you can entirely build a career right at the start of your practice, right just when you're out of college on mediation. So I'd suggest you work with mediation, but also do dispute resolution on a broader perspective, and engage with practitioners in both areas, and then decide how much you want to push that.
Thanks, Poornima. I think, Aneesh, there's a question which I'll sort of generalize and ask. There is this concern, given the lockdown, on what are the prospects of graduates who are waiting to graduate because they haven't graduated yet, and what are prospects as you see it in the foreseeable future?
So I mean, yeah, it's not been easy at all. So most firms did sort of delay their fresher intakes this year, but then the good news is that they have actually now started. So my data sort of primarily sort of still vests in the sort of what is tier one and tier two firms, the larger firms of the country. That's primarily because that's who we work with, but yes, it has taken a little longer than it would have. I mean, normally you would have already started working by now, but better late than never. Most firms have started virtually welcoming their fresh associates. Yes, on some in some practice areas and in some firms, the recruitment numbers would be a little lower than previous years, because I mean this is an unprecedented turn of events, this pandemic. So it affects business, not only the legal profession, but it affects everyone everywhere around the world. So lawyers are not immune to a pandemic. So yes, it's going to be a little tougher to find a job. It's going to take a little more time than it would have in the past. But I mean, again, if you've done well in law school and you're sure about what you want to do, and you stick to those firms, those professionals, those chambers, those individual lawyers, I'm sure that in time they will respond with a positive signal.
Thank you, Anish. Um, there's a there's a participant who's looking at moving from in-house to firm practice, Boski, and she wants some advice on how she could navigate this. Anish as well, if you could pitch in.
I definitely say that if you think that's your calling, please go for it. At the same time, it'll give you, having worked in-house, once you go back to the law firm, you'll be able to add much more value to your law firm's brief. As they say, any lawyer is as good as the brief, and if you're in-house, then your senior counsel is as good as you are when you're briefing your senior counsel. So there's absolutely nothing to feel awkward about. This is the right time if you want to move, if you're convinced that you would flourish better in a law firm. Yes. Having said that, but do be aware that a law firm also brings with it a lot of revenue generation pressures. At the end of the day, it's a business, and you have to be mindful of that. So if your heart lies as a litigator, if your heart lies in wanting to litigate and argue at the bar, then maybe a law firm may not be the right place. So you have to hunt for the right law firm that gives you the freedom to argue your own briefs. But if you're going to go back to a law firm and get frustrated with being a part of the larger ecosystem, where you feel, oh, I'm not getting a chance to argue my brief, or I'm too burdened with handling client expectations day in and day out, I can't manage the firefighting, then probably you'll have to look at just take a step back, evaluate, and then decide what would be the right time.
Anish?
I will wear my Vahura hat and say that nothing. It's I would like to look at your CV and sort of gauge whether it's possible. I take off my Vahura hat and be honest and say, listen, I don't think it's impossible. I think it's definitely something that you could do. It would really depend on what your body of experience lay within the in-house company that you work for, and what is the kind of work that you want to do with a law firm. As you become more senior, the transition sort of becomes a little more tougher. Like Boski said, the revenue pressures at a senior level do start coming in, and it becomes more difficult to come back to a firm. But depending on what you want to do and what you've done in the past, I don't think this border that existed in the past between in-house counsel and law firms are necessarily as wide, or as the wall is not as tall.
I can just add one thing as counsel when I get briefed. Boski is absolutely right. a person who has actually had in-house experience and thereafter the law firm experience brings a lot more value to the table in terms of the brief than a typical law firm lawyer who has started in a law firm and gone with the law firm. Because a lawyer who is trained only with a law firm tends to look at the law more and the business less. Whereas somebody who has come in-house understands what the business needs, marries it to the law, and then equips the senior with what he or she should have. And therefore, as Boski said, she's so right. Counsel is only as good as you have briefed the counsel, and therefore somebody with in-house experience and law firm experience is far better equipped to deal with a complex situation than a plain vanilla law firm lawyer.
We've overshot by almost half an hour. If all the panelists can spare a little more time, there's a question which is a little interesting, which I'll ask of all the panelists as requested by the participant. Another 10 minutes is okay? Will that be all right?
Yes. Tomorrow is a holiday. No arguments in any court, so I have all the time.
Tomorrow is a festival.
Yes, tomorrow is the festival. Ganapati Bappa Moria.
That's right. Okay. So here's the question: heart versus head. How much would you say is the ratio to what you present to your clients? Coming from probably the only non-student here. Heart versus head. How much would you say is the ratio to what you present to your clients? Heart versus head.
Wow.
If I may go, I do. I mean, I think of myself as a very much a heart person, but I don't think there's a conflict there. You must never lie to your client. You must always paint the correct picture. I mean, if you think that the client, it's how you say it that's important, of course, but you must not sort of set expectations unreasonably. If you think there is a case, make out the case, do your best, and clients will understand that. Whoever they may be, and they do recognize a hardworking lawyer, and they do recognize that you're doing your best. The heart is very much important for the profession. As I said, you must love the law to be part of any dispute resolution team. You must truly believe in the law, sort of as Dr. Menon used to say, is an instrument of social engineering, right? So you have to truly believe that it will change in every way we think and live. So I don't see a conflict at all. It's just obviously both have to go hand in hand, and each of our personalities are different. Some of us may be more heart, some of us may be more head, but it is what you are, and so don't have to change yourself just because you think there is a certain mold that a certain lawyer is built. And I think Sajan said that just because something worked for Palkiwala and something works for Mr. Poovayya doesn't mean that it works for you. So do what you think is right.
I'll jump after Poornima on it. Whoever asked this question, you should remember something. If you just apply your head and just go with your head, then the law is just a profession. It's only when you bring the heart to the table that it becomes a passion. And believe me, as a lawyer, you need to be passionate about it. You can't succeed as a professional, as a lawyer, unless you bring passion to what you do. And that comes only with your heart. And therefore, you need both. You need your head firmly on your shoulders is very, very important. But unless you bring passion to it, that difference in terms of the next mile never occurs. And therefore, please bring both to the table.
Sajan, there's just one small point that I'd like to add here to what you and Poornima have said. It's absolutely 100% in agreement with going in, with your heart and having a head on your shoulder. But I think we must also tell our listeners that it's absolutely okay that, today your heart might want something and your head might want something. And, a few years down the line, you might want to try your hand at something else. So, as long as you're not being impulsive about your decisions and you're taking informed calls about what you want to do and at what stage of your life you want to do, I think it's absolutely fine. We all have just one life. If there are people who want to try all three spectrums of their careers, go in-house, try your hand at the law firm, get a flavor of arguing and speak for yourself what works for you. Maybe a few years down the line, you might want to be at the bar. And that's absolutely okay to change certain decisions as long as, you're taking care of your mental health. That's most important in my opinion.
Aneesh,
I mean, after
ratio.
no, I think no. I honestly, I mean, what I wanted to say was, I think law is a profession for the mind, but the bar is for the heart. You really have to be in love with litigation to be a litigator, and I think that's the only thing I want to add. That's it.
I think
You
Devika, who
can't be
asked that
heartless
question,
at the bar.
She wanted a ratio actually of heart.
no, she also said she's asking it for the client. So I'm
Yeah,
specifically saying it from a client perspective that I have clients who wept in front of me, and I have had clients who have held their hands, and clients who've sent very heartwarming letters to you when they're individuals, to clients who are large corporations who have then referred you on to other friends and family. So the heart is very much part of the game, so and you can't obviously practice only with your heart. Your head must be there, and you must understand what you're doing. So whether it's to the client or whether it's to a judge, they have to go hand in hand, and there may be arguments about you being far too emotional or otherwise, but that's okay. I mean, that's fine. So it depends on what you want. Tailor it accordingly.
yeah.
Okay, thanks so much, all of you, for giving your time and sharing insights from your work and your experience. I think we've had a lot of the questions were common, and we've brought in different perspectives from in-house, from pure practice, like Sajan, from what recruiters expect, and the law firm practice. Thank you, and good evening. Thanks to everyone for participating and joining.
Thank you. Thank you.
Thanks for
Our
having
pleasure.
us,
Thank you very much.
This has been so much fun and
Great
learning
fun.
of us. Thank you.
Yep. Thank you.
Goodbye.
Thank you. Take care.
Thanks.
Thanks. Bye-bye.
Bye.